morning. On behalf of the New York State Science and Technology Law Center, we welcome you to a special webcast that we are happy to present to you today, thanks to the firm of Hoffman Warnick. We have some representatives from the firm, which is an intellectual property firm, full service, located in Albany, New York, with 17 attorneys. The founders of the firm are Michael Hoffman and Spencer Warnick. And we also have here today Carl Roth and I knew that would have David Rook. Thank you.
Hello, everyone.
And David will present for about 40 minutes about the case Standford v. Roche. And then there will be time for questions. You can email your questions into mzimme01@law.sy.edu, which you all have in the materials that were forwarded to you. So thank you again, and I'll turn it over to David.
Good morning, everyone. As Molly just pointed out, my name is David Rook, and I'm here with my colleagues today that have been introduced to you. And we're excited to be giving this presentation. I understand there's a number of you out there in different portions of the country. So I welcome you all to this today, and hope we can be of some service to you. I know that many of you are in the tech transfer field, and some of you may be more specifically involved in the field of protection of intellectual property law. Over at our firm, like you, we monitor IP development on an ongoing basis. It changes radically. There's things happening in the IP field all the time. So, as you do, we try to monitor cases of various sorts and see what's happening in the IP field. Now, as you know, approximately 1 month ago, the Federal Circuit handed down a decision entitled, well, the brief title is Standford v. Roche. Now, when we saw that decision, there were two qualities about it that struck us uniquely. One was that it involved a university setting. And some of our clients, and certainly some of our friends, are in the university environment with tech transfer divisions similar to the Stanford environment. And what struck us even further was that a sophisticated institution like Stanford ended up being handed nothing by the Federal Circuit. And so immediately we took an interest in the case. And as we read the case, we thought, well, this would be a good topic of discussion for our clients and friends in the tech transfer field. Mostly because we want to take a look at this decision, see what happened, and determine if there's anything that's possible to do to strengthen our position, reduce our possibilities of having a situation where we end up with nothing. As we go through, there you go. Oh, I'm going now. All right. I can't see it on this screen up here. So as we go through the presentation today, I just want to outline the broad topics we'll be covering. First, we'll be covering some key topics on the background of the dispute. We'll be talking about the Federal Circuit decision. And we'll be talking a little bit about Stanford's petitioning for rehearing en banc. The Federal Circuit decision was a panel decision. That's 3 judges. I'm not sure entirely which members of the audience know these things or not, so I'll just say quickly. A panel decision is persuasive among the circuit, binding on the districts. The en banc decision becomes circuit law, and that would be if all 16 judges of the thank you. If all 16 judges of the Federal Circuit were to rule on the case. Now, I do want to point out, as I go through this section, this outline, that anything I say is not meant to disparage any of the parties or to criticize any of the lawyering that happened in this case. As you all know, this is a complicated field, many different aspects to this dispute. I'm sure that everybody was working diligently and hard at what they were trying to do. So what we're trying to do with this is where are we now? What happened? And how can we learn going forward? So the second half of the presentation, we'll be talking about the university perspective, the inventor perspective, and then entertaining various questions as we go along. And I'd like to say that as we get into the university perspective and the inventor perspective, we know from our work in the IP field that many of the tech transfer offices are stretched for resources. So what we have is, I guess what you would say is suggestions. We know that when you're going to have to look at your personal situation, at your offices, at your budgets, at your priorities, and determine what you want to do with respect to what we have to offer here today. Now, with respect to the background of the dispute, what we're going to focus on is that there were some interesting legal procedural things going on with the Federal Circuit decision. But primarily what we're interested in sharing with today is the Circuit Court's analysis of the competing assignment agreements that came about through some research that was going on at Stanford. In 1988, Dr. Mark Holliday joined two other Stanford researchers, Dr. Thomas Merrigan and Dr. David Castleseed, engaged in research to quantify HIV and correlate the measurements to therapeutic effectiveness of antiretroviral drugs using PCR techniques. That's polymerase chain reaction techniques. When Dr. Holliday joined Dr. Merrigan's lab, he signed onto Stanford's IP policy. He signed what's known as a copyright and patent agreement. And a portion of that, the portion that comes up in terms of the competing agreement, stated, I agree to assign right, title, and interest in inventions. Now, Dr. Holliday, in terms of his work, now you'll notice in terms of their research in the first bullet there that they were going to be using PCR techniques. And at that time, Dr. Holliday was not familiar with PCR. So he went to visit an entity known as CETUS. CETUS had a specialty in PCR techniques and actually had developed the PCR technique. Actually, a Nobel Prize had been awarded to one of their scientists in chemistry for his work in the PCR technique. So in 1989, Dr. Holliday goes to CETUS and signs a visitor confidentiality agreement, which, in part, stated, hereby assigns to CETUS my right, title, and interest in the inventions. Now, I do want to point out, every time that we mention CETUS in there, it's going to say later Roche, and I'll explain that in just 1 minute. Dr. Holliday did spend some time, I think 9 months at CETUS. He had a lab bench there. Then he used the PCR techniques with the other scientists at Stanford and reduced to practice at Stanford the 3 patented methods. They actually came with one parent application in May of 1992 and then resulted in, at this point, 3 issued patents related to that method, all with the same title, polymerase chain reaction assays for monitoring antiviral therapy and making therapeutic decisions in the treatment of acquired immune deficiency syndrome. The first one issuing in 1999. Now, in 1991, Roche purchased CETUS. Well, not entirely. Roche actually purchased PCR assets of CETUS via an asset purchase agreement. In 2000, a senior licensing associate of Stanford was doing a presentation at Roche and asserted ownership of these patents. During the 90s, Roche had begun creating an HIV detection kit using ostensibly some of the methods that were involved in these patents. And during 2000-2004, negotiations were underway for an exclusive license of the patents to Roche. Those negotiations did not result in an agreement, and in 2005, Stanford filed a patent infringement suit. And Stanford alleged in that suit that Roche's HIV detection kit infringed the patents. Now, Roche responded both as counterclaims and as affirmative defenses that, among other things, that Stanford lacked standing to bring suit, that Roche possessed ownership, license, or shop rights of the patents. And those were actually each of those were slightly different arguments in the lower court. And finally, they argued that the patents were invalid. Now, the district court ruled that the patents were invalid for obviousness. And that decision was a separate decision from the agreement and ownership decision. Those were two different lower court decisions. We're not really here today to talk about the validity of the patents, but obviously, in terms of this dispute and as it goes on, overcoming that hurdle, having the patents ruled invalid, is a separate hurdle, an important one to boot. But that would be the subject of an entirely different seminar, perhaps a whole day. And at the time, the court also denied Roche's possessive assertions of ownership. Any of the arguments that Roche brought forward to assert ownership, the court rejected. Now, at this time, I do want to commend everybody. If you may have read the Federal Circuit decision. If you haven't taken the time to locate and read the lower court decision, I want to commend that to you. As we go through this, the Federal Circuit decision, in my view, has some weak points to it. And the analysis, both in terms of the factual background of the dispute and the legal analysis, is not nearly as strong as the lower court decision in this area, which is a much more interesting, in some ways, document to read. However, in terms of the outcome, we still, as entities, would prefer not to be involved in a situation where we're arguing that we're right. What we'd prefer to do is end up before litigation successfully negotiating a license to our products. Both Stanford and Roche appealed the decision. Now, at that time, essentially the lower court had ruled Roche has no assertion to ownership. Stanford appears by presumption to have ownership because they had a patent, and but at the same time they had been ruled that the patent was invalid due to the obviousness. I apologize, I haven't been keeping up with your little bullets here, but many of you already have this in your papers that have been provided to you. As I noted before, the panel decision of the Federal Circuit is not an en banc decision. What did the court rule? The court ruled that Roche was precluded by the California statute of limitations from obtaining a judgment of ownership. But in addition, the court ruled that the Roche could use its claim of ownership as an affirmative defense. So they were barred by the California statute of limitations from claiming ownership, but they could still use the claim of ownership as an affirmative defense. But interestingly, and to Stanford's surprise, I'm sure, they ruled that Stanford obtained no interest in the patents as a result of the competing agreements and therefore lacked standing. Standing to sue is a legal concept, and we do have a bullet on this at a later page, but essentially standing requires that you have to have some interest in the lawsuit in order to bring it. For instance, I could not have brought a suit against Roche for an alleged infringement of Roche against Stanford, for instance. I would have absolutely no interest except some sort of academic interest in the dispute. So I could not bring the dispute. So that's a sort of an extreme example of no standing. So the key issue that we wanted to talk about with you today is this notion of the competing agreements. And if you go to the Federal Circuit decision, this is under the bullet chain of title. Now the first thing that the court points out is that under state law resolves who owns patent rights and on what terms. So in other words, for those of you interested in the law, the federal court is looking at this case, and at times the federal court will defer to state law, but at other times it refers to federal law. So first they point out that state law governs certain aspects of patents. But then it points out that Federal Circuit law resolves questions as to whether contractual language affects a present assignment of patent rights or an agreement to assign rights in the future. And if you think back to the two clauses in the 1988 and 1988 agreement that Dr. Holliday signed with Stanford and CEDAS respectively, it falls squarely in what the Federal Circuit law resolves. So when the Federal Circuit looked at the 1988 agreement, they said, well, agree to assign means a mere promise to assign rights in the future, not an immediate transfer of expectant interest. And that is a subsequent written instrument is required. So Dr. Holliday's agreement with Stanford is that at some later time, he would assign his rights to Stanford. And in fact, that did take place. Dr. Holliday did assign his rights to Stanford after the patent application was filed. The court then said that do hereby assign means a present assignment of a future invention. Once the invention is made, an application for patent is filed, legal title to the rights would be in the assignee by operation of law. So what they're saying is that the agreement, as it was worded in the Dr. Holliday's agreement with CEDAS, the visitor confidentiality agreement, that he agreed that as soon as an invention arose, however they were going to define that, and in this case they defined it on a constructive basis with the filing of the patent application, is that without an additional writing, as operation of law, assignment went to CEDAS. The assigner inventor would have nothing remaining to assign. Now, what that means is that when Dr. Holliday ostensibly completed his requirements under contract to assign his invention to Stanford, he had nothing to assign them. What the court is saying is that CEDAS took the invention by assignment, by operation of law, so that when Dr. Holliday signed documents assigning to Stanford, it was gone. There was nothing to assign. Interestingly, if you read the lower court decision, it comes up with a completely different result here. Basically, he said, and I may come back to this because it comes in with some of the arguments, that that presumptively Stanford had the agreement, and under the Bayh-Dole Act, interestingly enough, that there was nothing for the inventor to assign to CEDAS. So and it didn't have to do with the competing agreements. They actually relied on the Bayh-Dole Act. And we'll get to that as well. So in terms of the Federal Circuit decision, one thing they talk about is whether Stanford is a bona fide purchaser per 35 U.S.C. 261. Stanford argues they were a subsequent to CEDAS good faith purchaser when Holliday assigned to Stanford. This also involves the assignment, the recordation of assignments. There's an argument involved that CEDAS did not record its assignment, which they did not, and that Stanford did record their assignment, and that when they took the assignment from Dr. Holliday, that they qualified as a bona fide purchaser. But on the facts, the court says no. That Stanford had notice of Holliday's work with CEDAS, even if Stanford lacked specific notice of the CEDAS-Roche agreement. And really what they're relying upon here is a constructive notice with respect to the I don't know if you could find that particular argument in here. The court had something interesting to say with respect to constructive notice. The Hollidays, what they state is that Holliday's assignment was in breach of Stanford's agreement, creating a cause of action against Holliday, not CEDAS. Well, as you know, this is not a good victory for any of us in the university setting, because we don't want to be in a situation where we're suing our inventors. Now, the second argument that was raised and addressed by the Federal Circuit decision is whether the Bayh-Dole Act negates the Holliday assignment to CEDAS. Now, in this particular case, this is where I particularly commend you to the lower court decision as well. You know, on the facts, the court says no. the court agrees. The Stanford had a right of second refusal after the government refrained from exercise of rights. But the act did not automatically void Holliday's assignment to Cetus. Now, what's interesting here is that the Federal Circuit, there was a two-pronged argument in the lower court, and that the first part of it is based on Federal Circuit law, which is saying that the government, if there's a violation, if there's an assignment, and they don't get the assignment first, has a right to invoke forfeiture of the invention. The second part, and so the court here is agreeing, and what the Federal Circuit also said is that the title going to inventors and assignments and things like that is undisturbed unless the government invokes their right to forfeiture of the invention. But what isn't addressed by the Federal Circuit was the second part of this, which ultimately allowed the court to reach a different decision in the lower court. And that is that when an individual inventor is not a contracting party, the Bayh-Dole Act provides that the individual inventor may obtain title only after the government and the contracting party have declined to do so. Now, interesting, that language came out of the Southern District of New York in 2000, interpreting the Bayh-Dole Act. The essence of that is that in order for the title to vest in Holiday to assign to Cetus would have required a refusal by the government and a refusal by Standford before he had anything to assign. Therefore, the court says there was nothing for title, there was no title for Holiday to assign. Now, earlier I talked about standing to sue. A party has sufficient stake in order to bring suit. And basically what the court said is Standford cannot establish ownership of Holiday's interests and lacks standing to assert its claims of infringement against Roche. So that's the outcome. What they're saying is that when the assignment arose for Cetus by operation of law, at the time Standford had nothing, so when Standford brought suit, there was no reason for them to be in court. And in fact, you can be dismissed for standing at any time in the process. So even if you go all the way up to the Supreme Court and had all kinds of rulings, you can still be knocked out for standing. At our office, we had an opportunity to talk with Catherine Koo. She's the Director of Office of Technology Licensing at Standford. And she informed us at that time that they're petitioning for rehearing en banc by the Federal Circuit. And frankly, reading this decision, it's a good idea that they're doing so. For all of us. Some of the arguments they're presenting are that the permissive language of will assign in the Stanford's IP policy is due to Bayh-Dole, that they cannot take title until they know the government is not interested. I think, as I read these two cases, and I understand there may even be somebody from Stanford on the line today, as I read these two cases, I think it's a good idea to work on the Bayh-Dole perspective, and certainly from the public policy perspective, that you don't want to eviscerate the intent of Bayh-Dole with this decision that's been handed down by the Federal Circuit. I think if I were looking at this, I would be inclined to see if I can resurrect that lower court, that section of the lower court ruling, which is talking about the inventor's responsibility to seek refusal, first from the government and second from the contracting party. I think that will also strengthen Stanford argument on rehearing. Now, the patents covering, the other argument that they intend to pursue in the rehearing en banc is that the patents covering quantifying HIV and correlating the measurements to therapeutic effectiveness, using PCR techniques, is that the PCR techniques per se are too tenuous a relationship with matter learned at Cetus. I'm not going to get too much into that particular argument. The Federal Circuit decision itself does not reveal a whole lot in terms of what was determined from the various depositions, interrogatories, and discovery documents that were put forth. There's a lot of arguments that cut both ways for both Roche and Stanford, and if you take an interest in this case, I would read that and and you can arrive at your own decision, at least from what's on the lower court's ruling. But the real question is here is not so much for us who's right and who's wrong. The real question is, how can we avoid this? Even if this is a bad Federal Circuit decision, we don't want to be on the end of that bad federal decision. And we don't want to have to be in a position arguing that we're right. So what might we do? Well, ultimately, I think that everything we talk about here today, even though it might affect your agreements with inventors, is that our strongest position will be to address third-party entities as much as possible. Strengthening notice to third-party entities of assignments that exist, IP policies that exist, agreements that exist between our position as a university and our inventors. Now, if the university prefers an agreement to assign future inventions, and we do have a note here, if we believe that Bayh-Dole requires it, I'm not sure that Bayh-Dole does. And as I read the Federal Circuit decision as discussed in the lower court that addressed violations of Bayh-Dole, that may not be necessary. But nonetheless, in the university environment, it may be necessary with our researchers. They may not want to assign, they may not want to make a present assignment of all their future inventions. So the university philosophy very well might be that we have to keep this kind of language in there. Again, this is for your institutions to determine in your relationship with your inventors. Under those circumstances, what you want to do is consider strengthening your policing of inventor activities with other entities and strengthening your IP policy and agreements. And one of the areas where this can be strengthened the most is when you have your agreements with your inventors. Now, I'm going to be referring to inventor agreements here, and every institution seems to have a different name for it. But generally, there's some kind of document that the researchers sign, that's some kind of an agreement that talks about assignment of inventions that occur while they're with the parent institution. So I'll just refer to those as inventor agreements, and you can insert whatever name you use for them for your institution. So where possible, you want to assert in your agreements that you have a first right of refusal for these inventions. So that there's a reminder in the contract that before any other assignment is made, regardless of what the wording is with that assignment, that the inventor has an obligation to offer it to the parent institution first. We'd also like to suggest considering requiring inventors to disclose to the university, require to disclose to third parties the university IP policy and agreements involved in research. So if they make your inventors aware that if they go to third-party entities for any reason, that they have with them the parent institution's IP policy and agreements. Now, that may be impossible for the tech transfer office to take care of, but maybe perhaps within your institution there's a way to have these documents available in the various labs or research places for the inventors to have and disclose. Consider requiring the inventors to submit all agreements before executing if the manpower allows. Now again, depending on the size of your institution, this could be a daunting task. So again, you have to look at your priorities, and perhaps one way to go about this is in the tech transfer area, I'm sure you know the hot items of research, the ones that have high economic value, and perhaps you can flag them with different priorities. So that when these agreements perhaps come in for review before they're executing, that at least you might be able to flag them and say, well, we better take a close look at this agreement because this is in a priority one category. So maybe there would be a suggestion of managing the workload. Now, alternatively, if consistent with the university philosophy and IP policy of the university, you could have a present assignment of future inventions. Again, there's the question, because certainly it appears from our discussions with Stanford that they may be asserting that Bayh-Dole requires that they not have this in the provision. But you could take this up with general counsel and determine your understanding of Bayh-Dole. And again, I would recommend to you reading the lower court analysis of this area under the Bayh-Dole Act and determine for yourselves whether or not you can include that. And certainly, that would have obviated the competing agreements, wouldn't it? If Standford had had a present assignment of future inventions, and CETUS had present assignment of future inventions, then the court would have been left with two entities arising at the same time by operation of law, an assignment, and they would have had to sort the whole thing out differently. Now, probably you've begun to see a wrinkle in this, and that is to evaluate the content of the claims. As you're all familiar with the patents, and the claims are marking out what is it that we're assigning. Now, there's certainly argument, and I believe this is what Stanford is intending to seek a re-argument on at the rehearing, and that is that whatever was developed at CETUS is not carried over to the actual claims. Their argument, as I understand it, that it's too tenuous. That was actually addressed by the lower court, and there's a discussion on that possibility. Now, one thing we didn't discuss in terms of the background of the case is other third-party agreements, such as material transfer agreements. These actually have bearing on the lower court's decision, and they had a bearing on both the licensing right argument and the shop right argument made by Roche. There was licensing provisions in the MTA agreement. The lower court ruled that Roche, in purchasing, in the asset purchase agreement, did not purchase those rights. That they had to go back to Stanford for somebody to sign off on those, or had to be agreed to by CETUS, neither of which happened, and they said that Roche did not acquire them. It might have been an argument if CETUS was still there. They weren't. The shop rights argument failed because there was so many aspects of this governed by contract that there was no reason to rely on shop rights, which was a common law division of ownership. So if possible, you want to require third parties, actually place an obligation on third parties to submit all documents to the university for review, including but not limited to any documents to be signed by the inventors. So if possible, we want to get notice to the third parties, and that's where the third bullet here comes into play. When the university is not directly involved, but the third party is known, place the third party on notice of your various rights and requirements. And perhaps this could be drafted into a form letter of some sort, so that at any time when your researcher or the lab or the tech transfer office or whatever entity had notice of an outside third party, a letter could go out explaining the relationship of the inventor to the parent institution and placing that third party on notice, say, not to obtain assignments of rights, that a parent institution has already asserted a certain assignment of rights. Perhaps if there's government funding involved, remind the third party of the Bayh-Dole requirements, etc. In other words, what's happening here with these recommendations is that we want to create a situation where the third party is not innocent of these situations. And then you can set up from a litigation perspective two possibilities. Perhaps going after them as a third party beneficiary of a breach of contract, or perhaps going out after them for tortious interference of business relationships. But you want to be able to get to those third parties if litigation develops. And the thing is, if you create that strength, then you might not end up in litigation, as you all know. Because if somebody's saying, wait a minute, we don't want to end up in this situation, we're going to get hurt as well, then maybe your negotiations have a stronger perspective. And finally, we would recommend that to the extent possible, to make your agreements uniform. It would alleviate much of the work associated with the tech transfer office and all of the recommendations we're making, because if we know it's in those agreements, then we don't have to review them every time to see what's in them. We don't have to look for specific paragraphs. We know it's in there. And we can design them a particular way, particularly with software that we have, that we could actually select certain paragraphs if we needed to delete certain paragraphs or insert them for a specific situation. But the language could be uniform. And finally, we have the inventor's perspective. And I'm not sure there are any inventors in the audience today. But we do want to make the inventor aware. Please be aware of your obligations to the school and your employment agreements and the school's IP policy. I think it's the intent of the researchers and the inventors to meet their obligations. There's nothing in these decisions that suggests that any of these researchers or inventors were doing anything underhanded. Everybody knew that work was being done at CETUS. So the important thing is we can't just sign a document when we go off to third parties. So, and that's the next part. Don't sign these documents without somebody's review and approval, preferably at the university where you work, in accordance with the IP policy. If you look at a document that says something about assignment of your rights or licensing of your rights or anything along those lines, well, just take a moment if you can. Don't sign it as just another legal mumbo-jumbo kind of thing. Because these things take an enormous life of their own in litigation. All of a sudden, this thing you just signed in passing becomes sort of the nightmare of your life in the deposition proceedings and in the courtroom. You don't want to be cross-examined on a document you signed and saying that you didn't read it. And the result is, on an individual level, that you risk personal responsibility if you sign these documents. As you see from the Federal Circuit decision, they say, well, Stanford had a cause of action against Holiday, and it doesn't appear, of course, that they're going after him. But certainly, if there were other facts or relationship differences, that possibility exists. So why expose yourself to that possibility? So again, these are just some suggestions. Looking at this case, we want to learn from it. I believe also, and I don't have that information today, that if Stanford is successful in petitioning for a rehearing of the decision on bonk, that there will be opportunity to file amicus briefs. So to the extent you're interested in it, keep an eye on it. You may, in your own interest, want to do that. So I want to thank you for coming today. And if you have any questions, maybe I can answer them, and my colleagues are here as well, and maybe they can answer your questions too.
I'd just like to reiterate that the questions can be sent via email. In the email you received about where to set your web browser, it has the link to ask questions. So you can send them via email. And are there any questions right now?
I have a question from the audience.
Mr. O.
Hi. So I'm with the Tech Transfer Office. So the way we work is we have a faculty policy that faculty sign when they come on board, which states,
I'm not sure that they signed it.
well, first of all, they're supposed to sign it. Let's put it that way. They're supposed to sign it. Is that okay? Mm-hmm. So something is supposed to be signed when they come on board, and then they sign an assignment document when they're actually applying for research grants. They also sign assignments when we file the utility application. In those situations, we're fine. It's the situation where the professor is going outside of the university and then they're signing documents that the university is not aware of. Now, can we mandate the professor to show us all of the documents that they're signing outside of the university as part of an employment contract? That's an employment law question. But
Yeah. Well, if I might, I think that when you get to the word mandate for a lawyer,
Right.
I want to back off of that a little bit. Number one, what I would do is certainly look at that question, and what you want to do is talk with probably general counsel for your institution about whether you can mandate. Certainly the parent institution has definitive interest in what the researcher is doing once they step outside, and they are going to step outside. We know that. This work with CETUS in this case was needed by Dr. Holliday to pursue his research. So we know that our researchers are going to do that. So what we do want to do is, I would suggest that we could put in our agreements with researchers, yes, that you have to do two things. One, you need to disclose to the third parties your agreements with us and our IP policy, and the third party needs to disclose to the parent institution any documents that they're expecting the inventor to sign, or any other thing that's ostensibly connected with the researcher's visit to this third party. Because you'll be charged, as soon as the inventor steps out and starts dealing with third parties, the entity, the parent institution, will be charged with knowledge of that arrangement, even though you don't have specific knowledge of it. The actual wording here I was looking for earlier is Holiday's knowledge of the assignment is imputed to Stanford. In other words, Stanford didn't have any specific knowledge, all right? But it was open, in terms of the research that it was doing. And what the court then states, and I found this slightly humorous, maybe it's just lawyer humor, without delving further into the intricacies of an area of the law that most lawyers are content to leave behind in law school, the court concludes that Stanford's imputed notice defeats its status as a subsequent bona fide purchaser of Holliday's interest in the patents. So what it's talking about there is that you can impute to the institution knowledge of that arrangement. So you really need to build into, we would suggest that it's possible to build into the contract with your researchers an ability to exchange those documents, and that it would strengthen putting your third party on notice. Not just you don't want a cause of action against your inventor if you can help it. Maybe you'll need that to get to the third party, but you still want to strengthen notice to the third party. That's who you want to go after if there's an infringement. Does that help, Mr. Rowe?
Yes.
I was hoping you could give an overview of how you see, or if you could discuss Bayh-Dole and its relevance to this decision, since it's surprising the way it was interpreted by the court.
Well, as I said, I think the better legal analysis of Bayh-Dole is in the lower court decision. And interestingly, the Federal Circuit stopped halfway. Why? I don't know. Again, I'm not here to disparage people's work, but at times the courts are interested in reaching expedient conclusions, and maybe that was part of this. But the second half of the argument with Bayh-Dole was left unaddressed completely. The first part of it everybody seems to get right, and that is that there was nothing preventing Dr. Holliday from signing various documents of assignment. And the mere existence of Bayh-Dole was not going to void those arrangements, those titles, those vestments, those assignments. What Bayh-Dole creates is if the government has not refused the assignment first, that they can go after whoever ostensibly has the invention and invoke forfeiture of the invention. And so the Federal Circuit in this case agrees. They said, well, we don't see where Bayh-Dole voids the agreement. But the lower court took it a step further, and there was a second clause in there. It's section 35 U.S.C. 202D, which states, if a contractor does not elect to retain title to a subject invention in cases subject to this section, so the contractor in the case is Standford, the federal agency may consider, and after consultation with the contractor, grant requests for retention of rights by the inventor, subject to the provisions of this Act and regulations promulgated hereunder. Now, the Southern District of New York in 2000, now that's a district court, right? It has only persuasive power on anything that happens in California district courts or certainly on any circuit court level. But they looked at it and they said when the individual inventor is not a contracting party, therefore the Bayh-Dole Act provides that the individual inventor may obtain title only after the government and the contracting party have declined to do so. In other words, the inventor has no capacity to sign anything until both have refused. And that's why they came up with an exact opposite conclusion in the lower court. They said he had nothing to assign to CETA, so they didn't even address the competing agreements. They didn't have to address the assignments. They said it wasn't possible for the VCA to be effective because he hadn't complied with those two refusals. Does that make sense?
Yes.
I can, if you wish, you can even, since you're here in the room with me, I can, if you'd like a copy of this part of the analysis, or the whole case for that matter.
I don't think. Any questions? Okay, well, I'd like to thank you very much again for this wonderful presentation. And viewers, if there are any other questions, feel free to email them. And the entire webcast will be posted within the week on the NYS STLC at syr.edu website. So thank you very much.